Mr. Speaker, should judges be allowed to use a non-citizen's immigration status to issue a more lenient sentence to a non-citizen convicted of serious crimes like sexual assault, just so that they can avoid deportation? The answer is no. And tonight, I'm pleased to speak to Bill C-220, the One Law for All bill, which represents and reasserts the principles already laid out in the Immigration Refugee Protection Act with regard to the deportation consequences associated for non-citizens convicted of serious crimes like sexual assaults in Canada. The vast majority of people in Canada who have immigrated here abide by our law. So removal from Canada for non-citizens after being convicted of a serious crime is a no-brainer to protect everyone, the value of Canadian citizenship, and frankly, just every person who resides in our country and plays by the rules. In recent years, there have been multiple instances of judges issuing sentences to non-citizens convicted of serious crimes that were designed to allow them to evade deportation. This is unfair, and it is antithetical to the principles of fundamental justice and has eroded Canada's immigration consensus. In March 2024, a 24-year-old non-citizen from Surrey, BC, received a conditional sentence of 2 years less a day for aggravated assault and possession of a weapon after stabbing a stranger. Sounds serious, right? Well, what did the judge do? The judge rejected the Crown's 4-year jail recommendation so that the non-citizen would be able to avoid deportation. In 2024, in BC, a non-citizen was convicted of fraud and received a 6-month sentence, which a judge shortened from 10 months so that he could what? Avoid deportation. All this consideration for non-citizens convicted of serious crime to avoid deportation. But what about the victims? What about the value of Canadian citizenship or the responsibilities associated with being in our country?